Now, as I'm sure you've read or heard in the news, there have been a number of cases recently where rape has been alleged, but the accused has not been brought to court or the trial has collapsed because of digital evidence being uncovered. In the most recent, involving Samson McKaylee, pictures were found on his mobile phone of him and the complainant apparently cuddling in bed together. The Crown Prosecution Service dropped the case when the photographs came to light, as there was no longer a realistic prospect of conviction, and he will face no further action. Turning to other cases, there are issues about digital material, texts or photos. Why are they not being discovered early by the police? Given that it's illegal to raise a woman's sexual history in a rape case without the consent of the judge, how far back in digital history is it permissible for a defence barrister to trawl, and how might juries interpret digital images? Might there be a risk of reputations being destroyed in a, well, she was a bit of a party girl kind of way, suggesting she must have been asking for it, as used to be assumed if she was wearing a short skirt? Well, I'm joined by Tana Adkin QC, who's a barrister who specialises in prosecuting and defending in cases of rape and sexual offences. And Alison Saunders is the Director of Public Prosecutions. Alison, why is digital material not being discovered early by the police and shared with the defence?
I think there's a real cultural mindset which we need to get into about we live our lives on our phones now. So if you think about what you do on your phone, your whole life is there. There's virtually a computer on there. So we don't ordinarily trawl through people's lives, but what we need to do is think about, if we seize a phone, what will we get from it? What should we be looking for? So if people know each other, have known each other, say, for a day, you might look at their texts between each other on that day or perhaps the day after. But you wouldn't and couldn't, without a huge amount of resources, completely download a phone and trawl through it all. If you just think about the amount of data on there, I mean, we are carrying around computers with masses of data, but we do need to be thinking about what is there that might either assist the prosecution or undermine and assist the defence.
Donna, how satisfied are you that these things are being looked at in a useful way to the defence or indeed the prosecution?
Well, I'm afraid from both points of view, effectively members of the bar are not satisfied that this is being done properly and in good time, so that cases can be prepared properly for trial in good time, which is in the interests of all concerned. Disclosure should be robust right from the outset. Officers looking at material to see what is relevant, and then it being put either on a schedule, if it's not to be disclosed to the defence, and put on a schedule in a way so that that can be reviewed later if things change. That is not being done. The Inspectorate, Her Majesty's Inspectorate, that reported independently last year, said this was not happening. And effectively, I can say in court, we are not seeing this happening as a matter of course, which it should be, so that we can have confidence in the disclosure process.
Alison, what did you make of comments that were made around the review that's been taking place, that there's a misplaced culture of believing the victim?
Absolutely not. I mean, we have done a lot of training for prosecutors, and I can only talk for prosecutors, that they need to question, they need to look at cases and apply the code for Crown prosecutors.
And what about the police?
The police have had training as well, and I think they are accepting that perhaps they have gone too far around the believing. They need, part of their obligation is not to believe a victim or a complainant, but it's to investigate the case and pursue all reasonable lines of inquiry, which include exonerating a suspect. And just to sort of go back on the disclosure point, one of the things that I did yesterday was I held a seminar with members of the bar, the Law Society, police and the judiciary, and we came up with some really concrete proposals about how we make sure we have dealt with digital material, how we demonstrate that to both the court and the defence, so that we can have early engagement, because some of the issues are about not knowing what we should be looking for early enough. So when we get photographs that show actually there was a very different slant on the relationship, we can review the case and drop it, as we did in that case you mentioned.
Tana, given what Alison said about the amount of material that people have on their mobile phones or tablets these days, how far back would you say in the digital history of a person involved in a case is it acceptable to go?
Well, I think on this particular topic, Alison and I agree, because it must relate to what is relevant at the time. So every case is different. If a relationship is a very short-lived relationship, clearly material will only be relevant if it's very limited to that space of time. But there is a limit to resources, and the police and the courts cannot go back year upon year trawling through lots of information being held on a phone. So there has to be a limit, and that has to be realistic, but they have to at least have a plan of what material they're looking for, what might arise and what might become relevant, because sometimes relevance isn't always obvious, and that needs to be considered at an early stage and then revisited. So officers making the investigation initially certainly should document what is there, so that at least later that can be reviewed.
How concerned, Alison, are you that the reputation of a complainant might be damaged by looking back at her digital history? You know, how would a judge rule on such evidence as pictures taken of her at a party, she was drunk, she was behaving outrageously, and that might be shown in court?
I think, again, that's where we very much need to go before the court and apply the law as it is. Section 41 would apply to that. Are they relevant?
Section 41 is the
Section
sexual history
41,
rule.
exactly. It prohibits complainant's sexual history being rehearsed in court unless the judge rules that it is pertinent to the allegation in question that he's trying or she's trying. So again, it's very much around what is the relevance of this? You know, does it go to an issue in the case or not? I would sincerely hope it wasn't, because it's about what happened between those two individuals. So I can see why it would be a worry to complainants and may deter some people from coming forward. But Section 41 is there to protect them. That's why, again, it's about the relevance and discussing between the prosecution and the defence at an early stage what is the relevance, what should be allowed in and not.
Tana, how do you reckon a judge would rule on such material?
Well, fortunately, Section 41 appears to be working very well in courts. It's very rare, and indeed the Ministry of Justice reported just last month that according to their statistics, it's very rare for an application to rely on this sort of evidence to be granted. But it's very important to remember that Section 41 is very restrictive. Section 41 restricts evidence in relation to behaviour only close in time to the events themselves. So it's not trawling back many, many years to see what information may be there. And it's only permitted by a judge if to not allow it would cause there to be an unfair trial. So there is a high test, and judges are applying that test. And I can say that in my experience, it's rare for a judge to grant an application for photographs or other material in relation to sexual history to be put before a jury.
Now, what about how a piece of digital information might be interpreted? Let's say you have a picture of two people in an apparently affectionate situation, or a series of affectionate texts that have been passed between two people. That doesn't necessarily mean that there was consensual sex. How might such information be used by the defendant?
And that's why it's quite important to understand the context of the case, and each case has to be looked at individually. So for example, if you have a case where a complainant is alleging some sort of coercive, controlling behaviour, you can see why that might put a different slant on pictures which look as though they're entirely voluntary. But that's again where the jury have to be able to weigh up all the evidence and to hear both the complainant and the suspect and make their own decision as to exactly what it means. But I do think we have to be careful. I've certainly had texts or messages on my phone where I think one thing, and then when you speak to somebody it means absolutely the opposite, and we all use different terminology on our phones. So I do think it is something we need to be careful about.
Tana?
Well, I agree. We do have to be careful about interpretation, because it's not for lawyers to interpret the images or the material, it's for the jury to interpret it. And it's very important in the court process that both the complainant and an accused have an opportunity to comment and put forward their interpretation. And it would be a matter for the jury which of them they consider to be the truth or which they consider to be accurate. It's not right for that decision to be taken at a much earlier stage as to who is to be believed according to an image, because of course there may be other interpretations.
How much catching up, Alison, do the police, the CPS, the lawyers need to do on this digital material?
I think we have to realise that now people live their lives on their phones or their tablets, whatever it is, and that's where there are conversations which we would never have known about before, because again, a lot of this would probably have been conversations you've had with a girlfriend or a chap or a friend somewhere, which nobody would know about. Now it's on your phone, it's recorded, it's there forever. So I think we need to be very careful about how we do this. There are data protection laws. We don't want to be trawling through everybody's holiday photographs from the last 10 years. So we need to make sure that we understand all the issues. We have done training with some digital companies to allow prosecutors to understand what types of devices are out there and apps so that they can understand how they're used. But there's also the resources around how do we deal with phones, the downloads, the going through them. So I think there's quite a lot that we do need to think about.
Alison Saunders and Anna Adkin, thank you both very much indeed.
Thank you
for being with us. And we would, of course, like to hear from you on this issue. You can text us or you can email us. Do let us know what you think.